question around the origins of the terms of reference. You remember that?
I don't remember specifically, but I know we did deal with it.
Don't you remember that the chairperson had asked, how did the president get to those terms of reference? Were they recommended by you or were they not recommended by you? And you denied that you had recommended them. In fact, you said that the terms of reference that were concluded were different to the terms of reference that you submitted.
I did say they're different.
Yes. If I could ask you to go to file 3 again, starting at page 163.
Is that your file?
Yes, file 3, 163.
I'm there.
Now, this is a letter written by Advocate Lekgetho, who is part of the NPA team. One of the annexures that are submitted is Annexure L. Now, Annexure L is a draft letter to be signed by the president. And it's itself not signed. And I want to show you it's at page, I must find it now. It's at page 181. Yes, it goes from page 181 to 183.
I see that.
Who gave the president this draft letter?
I did. I think it was the one that was attached to the bundle that was sent to the minister.
Yes, you gave the president this draft letter.
That's correct.
Now, if you then go to...
I beg your pardon, Council. Annexure L, is it that letter at 181, at page 181?
Yes, Madam Chair, it is. Yes.
Should we then mark it in your bundle? That would be...
Yeah. Yes, Madam Chair, we've just put this as a cross-examination bundle.
This is the exhibit document. It forms part of the exhibit document. This list, and that's just SB 10 to, you see, in that page 163, I'm trying to get my thinking right. Page 163, those annexures, including 12, Annexure L, draft letter to be sent to Advocate Chauke by the President. These documents form part of the list of exhibits that were handed to us last week, early this week.
Madam Chair, I need to just confirm with my junior. I'm not sure what the answer is. My junior tells me that, no, this is the first time we've been given this particular annexure. It's not part of the SB 10.
This is the letter that we spoke about that was handed from the bar. Which letter is this? Page 181.
Madam Chair, what had happened is that Advocate Batohi wrote to the Minister of Justice asking for the establishment of this inquiry, attaching various annexures. One of the annexures that were attached is Annexure L.
Annexure L is the presidential response to Advocate Batohi's
No,
formal
it's-
letter.
No, Madam Chair, it is a draft for the president to append his signature.
Oh, thank you.
Yes,
Thank you.
yes. Now,
Yes, just a minute.
yes.
Just a minute. Just want to understand because we have bundles and bundles of documents here. And these are the documents which had been requested.
Yes. They were
Yes, thank
requested
you.
in the cross-examination.
Yes, thank you. Now I understand. Thank you.
Yes. Now, Advocate Batohi, just to go back to the answer you gave, you accept that you are the author of this document.
Well, my office would have prepared it, and I attached it to the memo to the minister.
Well, when I say you, I mean you and your office. I'm not saying you were typing it, if that is how I came across. Do you accept that your office?
It came from my office, that's correct.
Yes. Now, if you then go to page 182,
I'm there.
item A, your office said to the president that the president must institute an inquiry into whether or not Mr. Chauke, in the Boysen matter, supported a decision to prosecute, notwithstanding that there was no evidence justifying the decision. Correct?
I see that.
Yes. Now, and then the balance there refers to the indictment in the case, which does not appear in the final terms of reference.
Sorry,
Correct?
can you repeat that?
After the word KwaZulu-Natal, can you see that?
I do see that.
It talks about sign the indictment. Correct?
That's correct.
That was your draft, but in the final terms of reference, those words have been taken out. Correct?
That's correct.
Yes. The rest of those words are exactly as they were in your original terms of reference. Correct?
That is correct.
If you look at B, B has been taken exactly as it is and put in the final terms of reference.
It appears so.
Yes. The same with C, has been taken exactly as it is and put in the terms of reference.
That appears so.
Yes. The same with D. It's a cut and paste.
I haven't checked, but I'll take your word for it.
Yes, well, I have checked. That's why I'm able to say the words sign and indictment appear in the draft. They don't appear in the final version.
Accept that.
The same with E. It is a cut and paste.
I'll take your word for it.
Yes. And
What do you mean? It is important for me to understand what you mean when you say you take council's word for it.
Chairperson, if I have to agree, then I'll need the other document next to me, and I need to then check word for word. In the interest of time, all I say is I don't disagree with council. I accept what he's saying.
And I should accept that to mean you agree with council. It is important for me to understand what you mean when you say you take council's word for it.
Chairperson, then I need to look at the other document to check every word to make sure it's correct. I'm saying is I have no reason to doubt council.
Therefore, you agree.
I don't doubt him, Chairperson.
I beg your pardon?
I do not doubt him.
Therefore, because you don't doubt the veracity of what he says, you agree with him.
If that's a conclusion, Chairperson, then so be it. But I
beg your
don't doubt him.
pardon?
If that's a conclusion, then it's fine, but I have no reason to doubt him.
Perhaps, council, we must go to the terms of reference.
Chairperson, may I just clarify one thing? That when I said that the terms of reference were different, look, I've not looked at this letter. Again, I have to go to the fact that this affidavit was drafted at very, very short notice. We attached documents that we'd sent in the interest of transparency so that Advocate Chauke's team has all of the necessary information. The terms of reference, when I said were different, I was not referring to this letter to the president. My understanding is that there's another draft terms of reference that I have looked at. That is my understanding when I said they were different, because there's another draft that we prepared, and I looked at that draft and the terms of reference, and that is a lot more different. But it appears what the president's office did is they have taken from this letter and added to the terms of reference. But we have another draft, which when we looked at with the terms of reference is different. My understanding was that we had submitted that draft as well to the president's office.
It is a very long answer. I just wanted to ascertain whether I understand your answer to Advocate Batohi. It may well be that he's going to cover those aspects that you are raising, but I just want to understand when you say you don't doubt the correctness of what he puts to you, whether you are saying you agree or not. That's just as simple as that. Maybe to assist Advocate Batohi, Advocate Batohi, you can take the terms of reference and contrast them with the contents of the letter and take Advocate Batohi to each and every part of that, so that when she answers correctly, understanding what has been put to her. It may take a bit of time, but it is important to get the correct answers from her in relation to the questions that you are putting to her.
Yes, Madam Chair, thank you. Perhaps then let's go to the beginning. If you could just take a copy of your terms of reference and then turn to page 4 of the terms of reference. And then let's start at 3.1.1.1. Yes. So if you exclude the preamble, because the president has included his own preamble, but you look at where it says supported a decision to prosecute the accused, notwithstanding the fact that there was no evidence justifying the decision. And you sought improperly to have the then acting DPP of KwaZulu-Natal sign the indictment in the case without providing him with the case dockets and or prosecution memorandum detailing the alleged evidence implicating the accused on which the decision to indict had to be made. You see there that the only words that are not included are the words "the indictment" in the case that are not included in the final draft. The rest of it is identical.
In other words, when you take the gazetted terms of reference, and I suppose I'm correct, Advocate Batohi, and you contrast them, or at least let's look at 3.1.1.1 of the gazetted terms of reference, and you contrast that with page 182A of what has been referred to you. Do you agree with Council's question?
Chairperson, I'm looking at the two paragraphs, and what I see in the terms of reference, what's also not in the terms of reference, I'm not sure whether council has covered this, it says without providing him with the case dockets and or prosecution memorandum. And in the terms of reference, it says to sign the case dockets and or prosecution memorandum.
Yes, we agree on that. That's the part I was reading, saying that's excluded in the final terms of reference. It starts with sign the indictment without providing.
In the terms of reference, it says sign the case dockets.
Now I'm saying in your draft, it
Yes.
says sign the indictment.
That's
So
correct.
that's all excluded.
That is correct.
Now, you remember where this became an issue is the reference to the word case docket, which you said does not exist. And then I asked, how can it not exist? Because you drafted these terms of reference.
Can
And-
you repeat that?
I'm saying, you remember where this discussion started? It was when I referred you to the words in the final terms of reference, case dockets. And you said there are no case dockets. And I asked, how can there be no case dockets? Because the charge sheet refers to case dockets. And then you says, well, I don't know about this charge sheet. I didn't prepare it. But what I want to refer you is
But
your,
can I respond to that? Because that's not what I said. And when the questions are too long, I'm not able
All
to
right, answer
respond
it
to
then.
things, and then it gets
All right.
confusing towards the end.
answer it.
So firstly, I didn't say there were no case dockets. I said there was no, to my knowledge, there was no racketeering case dockets.
Yes,
That was my answer. I did not say there were no case dockets.
I understand.
Because we know for a fact that there were 23
Yes.
murder dockets.
No, we are talking about the racketeering case docket.
So I think that should be made clear. I did say there was no racketeering case docket, to my understanding.
Yes. Well, this is the point I'm making to you. You said the entire charge, 3.1.1, is about racketeering.
Can you repeat that?
You said the entire charge in relation to 3.1.1 is about racketeering. That's the only case docket we are talking about.
So when I said it relates, I didn't say the entire charge. You know, we must look at the record and see what words I use, because they're being put to me as me saying the entire charge. What I meant is that the charge that we were referring to was racketeering.
Yes.
That's correct.
But that's the only charge that you have an issue with under 3.1.1.1 until 3.1.1.5.
That is correct. We're dealing with the
Yes.
racketeering.
Yes. Now, we come back then to the reference to case dockets comes from your own draft at A.
That's correct.
Yes. Can we then move on to
Can
the...
I explain that before we move on?
Yes.
I would like to explain it, because we leave things hanging and then there's no explanation for it. Chairperson, the reference to the case dockets there were 23 murder case dockets. And that is the reference to what this is saying is that he was not provided with those case dockets. Now, those case dockets could potentially or would potentially be the basis for predicate offenses in any racketeering charge. So it would have been important for a DPP to have all of that if he is required to sign an indictment for a racketeering charge. So that was the context, or what I would have said at the time with regard to case dockets.
Yes. Could I then move on to item B? Now, if you remove the first words in the Boyson Ketomana matter, you start with recommended. Now, I didn't see any difference of substance there. So you can compare it yourself and
I'll
tell
do
me.
that now. That's correct. It's the same.
Yes. If you look at C, if you compare that with 3.1.1.3, again, just remove the words in relation to the Boyson matter, starts with sought to defend. Again, I didn't see anything different there.
That's correct. It's the same.
If you look at D, let's do the same exercise and compare it with 3.1.1.4.
That's correct. It is the same.
Then the last of the racketeering charges is E compared to 3.1.1.5, starting with the words attempted. Again, I saw nothing different there of any substance.
That's correct.
Yes. Now, the matter of Lieutenant General Mdluli is worded slightly differently. The 3.1.2 starts with the words, the failure to continue with the charges against Lieutenant General Richard Mdluli for his involvement in the murder of Mr. Tefo Abel Ramokhibe. Those words do not appear in your draft. Is that correct?
That's correct.
Yes. But the critical part starts with caused, and it comes directly from your own paragraph F. Compare those words caused, starting with where it says Advocate Chauke caused at 3.1.2, and at F, look at after the Mdluli matter caused, and tell me if there is any difference.
It's the same.
Yes. Now this is the whole point why we asked for the draft that you sent to the president. What we can now see is that these terms of reference are virtually identical to what you gave the president, except for item A, which we discussed. And yet you've given evidence that seeks to distance yourself from your own terms of reference. Can you explain yourself?
Yes, I'm not seeking to distance myself from my own terms of reference. When I said that these final terms of reference were different to the terms of reference, the draft that we had submitted, Chairperson, I was not comparing it with this. This is not a terms of reference. The document that Council is referring to is a draft letter to the President. And I accept that we've gone through this exercise. I was referring to a draft terms of reference, which I understood that we sent to the President's office separately from this letter. Now, I have seen a draft of that document, but my office was trying to find the precise one that was sent to the President. And that is the document that I was referring to when I said that it was different from these terms of reference. I was not comparing this final terms of reference with the draft letter to the President. In fact, I've not even, but for when this letter went, I've not even looked at this letter in preparation for this inquiry, because I've just had no time to look at all of these documents. But to be clear, when I said it was different, I was not referring to the draft letter of the President. I was referring to a draft terms of reference, which we also submitted, is my understanding, to the Minister.
So the problem, Advocate Batohi, even this document we've now gone through painstakingly was never disclosed by you. It came up in the cross-examination.
So, Chairperson, again, I want to be very clear. There's nothing we want to hide in this matter. These documents are all referred to in the document that was sent to the Minister. They all attach as annexures to my SB 10. They are annexures A to M, which are referred to, well, it should be referred to, let me just get to SB 10 before I start saying things that are not absolutely accurate, because I do want to be accurate in the circumstances, as accurate as I can be. I'm looking at SB 10. It goes to annexure F, J, K. What's the last one? J. K is on 175. Annexure K, L, and M. So SB 10 refers by name to every one of these documents that was submitted in the bundle. We are not withholding anything, Chairperson. It was just that my affidavit would have been extremely long if we attached everything to my affidavit. So what we did is we referred to them and didn't attach them. But it's not withholding evidence, Chairperson. It's all in my affidavit.
You see, the problem with even with that answer is that if you are going to give evidence to this panel that the president has given you terms of reference that are different to what you submitted, you have an obligation to disclose to the panel that you also gave them Annexure L.
It's in my affidavit that I gave them Annexure L, so I'm not withholding it. It's SB 10, refers to Annexure L.
Just one, concern. And it's a concern that I have raised even in the past about non-provision of documents in advance. This SB 10 that you are now talking about.
Pardon me?
I say this SB 10 that you are now talking about is part of the documents that came late to the inquiry.
No, it's an...
The annexures, I'm still talking. The annexures, I think as lawyers generally, and even as human beings, we understand that it is very important that if you give me a document that makes reference to annexures, those annexures must be part of the document. The reason that you deem it fit to see it as an annexure to the document, it means it's an important document. So here we are today, we get these documents that we are told are just coming to surface to the inquiry for the first time today. Thank you. Is it soft? I'm told for a change, my voice is very soft. Okay.
I'm struggling as well. That's why I've been asking.
Oh, okay. Maybe there's something wrong with me. Sorry about that. I beg your pardon. Ordinarily, I'm told I scream. So I try to be a ladylike and talk softly. It doesn't help. Okay. You understand my concern?
I do.
Okay. Thank you.
Can I respond?
Yes, you may.
Thank you. So I did tell my team, we did say that we must look at my affidavit and make sure that all the annexures are uploaded. And I would have expected that all of these documents that are annexures to my annexures would have also been uploaded. So to the extent that they have not been, and I need to confirm with the team, I will apologize for that, but that was an exercise that they were meant to go through meticulously to make sure that every annexure to an annexure is uploaded. So I will check with them and see what the position is. And I would have thought that that would have been done by now.
Yeah, I don't want to belabor the point. I've just been tempted to reiterate this concern now. Thank you.
No, thank you, Chairperson.
Yes. Advocate Batohi, I'm sorry I'm not done on this point.
It's fine.
Because your claim that Annexure L was attached to SB 10 is a lie. If you go to SB 10 275, page 275, paragraph 31, and that's your letter of the 18th of August 2023. It says, it is further recommended that Advocate Chauke be afforded an opportunity by the President to advance reasons as to why he should not be suspended and a fitness inquiry be instituted against him. A draft letter is attached hereto as Annexure L. Annexure L itself was never there.
I think it is important for the record to make mention of the fact that SB 10 forms part of Advocate Batohi's affidavit.
Yes, indeed. Thank you, Madam Chair. So if you, Annexure SB 10, which is
It is SB 10 266.
yes, SB 10 266, yes, that's where the document starts. And the specific paragraph I'm referring to is paragraph 31, which is at SB 10 275. What I'm asking you, Advocate Batohi, is that your statement that Annexure L was included in SB 10 is a lie, because Annexure L was never attached to SB 10.
Before Advocate Batohi answers, which paragraph did you refer to?
Paragraph 31, Madam Chair, at page SB 10 275.
Chairperson, can council please repeat that? Because I want to be clear about what it is it's alleged that I'm lying about.
When you say, I said to you, you failed to disclose Annexure L. Then you said, I did not fail. It is part of SB 10. And I've now gone back to SB 10, particularly at paragraph 31.
Mhm.
What is stated there is that it is further recommended that Advocate Chauke be afforded an opportunity by the President to advance reasons as to why he should not be suspended and a fitness inquiry be instituted against him. A draft letter attached hereto as Annexure L. Annexure L was never attached to SB 10.
That is correct. Well, let me rephrase that before I answer that quickly. SB 10 is a letter to the President. Let me get that right. Is a memo to the Minister. And those annexures that you're referring to are annexures to the memorandum to the Minister. These would have been attached to the memorandum to the Minister, but they were not attached to my affidavit. So when the attachments to my affidavits were put together, the memorandum only was attached, not the annexures. But my point was that if one reads the memo itself, it refers to all of these annexures and gives a description of them. Let me just make sure that I am clear about that, because I am, just a moment, Chairperson, if you'll give me a moment. I just want to make sure that I am, I'm going to look at Annexure L now so that I am clear. Annexure L is in the bundle provided by Advocate Chauke's team. If I could just be helped with the page number, it will be useful.
I beg your pardon.
What page?
Let me correct that. Annexure L
Mhm.
forms part of the documents that were referred to or put together by your junior counsel, Advocate Lekgeto,
That's correct.
in a document that was emailed to Katleho Aubrey and to yourself, among other people.
That's correct,
who
Chairperson.
are mentioned in that email. So it is not correct that is provided by the team of Advocate Chauke. It was provided by your office, if I may put it that way. And that consists of the list of those documents at page 163.
Chairperson, I am not incorrect when I say it was provided by them. I meant it was provided in this big file. This is the file that I received from them. So that is what I meant. But you are correct indeed that this is something that came from my office and was sent to them by email.
And Advocate Lekgetho copied you that email,
Yes, that's correct.
so you had the document.
Yes, I'm not disputing that.
I'm just correcting the fact that it was provided by Advocate Chauke's team.
Chairperson, I'm saying I did not. What I meant when I said that is that this entire bundle in this black file has been given to me by Advocate Chauke's team. And it's in this bundle. That's all I meant. But of course, it comes from my office. When-
The source
Yes,
is your
absolutely.
office.
But they handed me this bundle. That's what I meant when I said they gave it to
It
me.
is very important to get it right, because we will get confused when we write the report.
Certainly, Chairperson, I will be mindful of that. So let me look at Annexure K. I'm going to try to, if anyone can guide me to the page, it will be quicker so that I can read this document.
I'm sorry, Advocate Toby, I interrupted.
Yes.
You had referred Advocate Batohi to
Paragraph 31, which is,
paragraph 31.
yes, simply to ask her, and I think she has done that, to confirm that that Annexure L was not part of SB 10.
Let me correct that, Chairperson. It was not attached to SB 10 in my affidavit, but it was certainly part of the memorandum that was submitted to the minister when it was submitted. But as I've been painfully trying to explain, we did not add all the annexures when we did my affidavit. And they have been now supplied to council, to Advocate Chauke's team.
Advocate Batohi, can I ask you, on your main defense on this issue, which is that this was a draft letter that you prepared for the president to sign when suspending Advocate Chauke, and you did not expect that these would be the terms of reference. Now, it is a bit of a puzzling expectation on your part. Why did you not expect them to be part of the terms of reference when you've given them to the president?
My understanding is that we submitted a draft, but I could be mistaken about that. But this was a letter to the president, and I didn't know what in fact, it was a draft. The president is at liberty to change that letter as he deems fit. We did not expect that this will find its way into the terms of reference. It was explaining to the president, in summary, what issues we had with Advocate Chauke's conduct.
Yes, there was another document, but we have not found the source of it. If you go to page 177 of file 3.
I'm sorry. This draft letter, as you have just mentioned, sought to convey to the president what issues you had with Advocate Chauke. As you have just mentioned, I just want to check.
Can we look at the draft letter again,
No.
Chairperson?
I'm referring to your answer that you have just given now.
Yes, I answered it, but when I realize it's being scrutinized to the level it is, I'd like to look at the letter.
No, Counsel. I'm asking you. You responded just maybe a minute ago that the draft letter sought to convey to the president what issues you had with Advocate Chauke. That was your response.
Chairperson,
Because I want to ask you a question on that statement.
well, I would like to look at the letter first.
No. Did you answer to Counsel his last question when I interrupted him, that you answered Your draft letter to the president was to convey the issues you had with Advocate Chauke. That's what-
Chairperson, that was loosely put. That is why I'm asking that I refer to the letter. There may have been other things there that I added, and I think in fairness, I should be allowed to look at the letter and then say exactly. I loosely put it. I didn't refer to it because we've been through some of it and we've compared it with the terms of reference. And it relates certainly to some of the conduct that we had an issue with. But there are other things in the letter as well.
No, I'm not talking about the contents of the letter. I'm asking you a question based on your answer to Advocate Kaitobi, that your draft to the president was to convey the issues that you had with Advocate Chauke. That was your answer, correct?
Chairperson, we sent a whole bundle of documents to the president.
No, Counsel. And I'm going to ask you again for the last time. When you responded to Advocate Kaitobi a short while ago, you said your draft letter to the president sought to convey to him the issues that you had with Advocate Chauke. The words, to convey the issues you had with Advocate Chauke. Is that what you said?
That's what I said, loosely.
Yes, thank you.
Yes. In fact, on this topic, the suspension letter of Advocate Chauke is identical to the draft that you prepared. I don't need to go through it, but we
That's
can
fine.
accept that.
Sure.
Yes. Now, I wanted to just come back to trying to understand what is the substance of your answer. There is a document headed the Presidency Draft Terms of Reference at page 177 of file 3.
What page is that?
177, Madam Chair.
177.
Yes. Now,
And what is the question with regard to that?
yes, thank you. If you could go to page 179. What this document does is to identify the issues to be decided.
What is this? I'm sorry.
Yes.
For the purpose of the record, what is this document
Well,
at page 177?
I'm very happy, Madam Chair, you've asked that question because it's one of the documents we received from Advocate Lekgetho. And I was going to ask the witness to explain what is the status of this document.
At 177.
At 177, yes.
Yes, thank you.
Yes. Advocate Batohi, if we could just go to 179. This document purports to identify the issues to be determined by the inquiry. At Roman figure 1 and Roman figure 2 in broad and generic terms, but does not identify any terms of reference in the same detailed sense that the gazetted terms of reference do. Now, who prepared this document at page 177?
So this is the draft terms of reference that I was referring to earlier, Chairperson. It was prepared by my office.
Was this a first draft, a final draft?
I can't recall. I assume it would have been the final draft.
And what happened to it? You gave it to the minister?
Well, I thought it would have been sent to the minister because that's why we drafted it. But I'm not sure.
Yes. In any event, the point I'm really trying to understand here is it's only at page 179 where there is an identification of the issues to be decided. But there are no actual terms of reference in that document at all.
The heading of the document is draft terms of reference.
Of course.
And in fact, there's nothing wrong with having broad terms of reference.
Now, what I'm asking you is there are no terms of reference in the document. There is an identification of the issues to be decided at page 179.
This is a draft terms of reference document. We can quibble about semantics, but this is the draft terms of reference. And at page 179, as you say, the issues are broadly defined.
Yes. The only document that specifies the complaints against Mr. Chauke to the level of the terms of reference is what we were looking at page 181.
That's the letter to the president and not
Indeed.
the draft terms of reference. that
Indeed,
was drafted.
yes.
That's correct.
And that's what ultimately makes it as terms of reference by the president.
That was
Page 181,
that's the president's decision.
yes. Thank you. Now, in relation to that final document and your own draft, you've never identified the issue of Mr. Chauke acting in excess of his authority as part and parcel of that letter at page 181.
Chairperson, the terms of reference have got to be drafted, have got to be read in its entirety. If we look at page 178, it refers to, well, before that, Chairperson, if I may, page 177 refers to the relevant sections in the Constitution. I won't go through all of them. It refers to sections in the NPA Act. And then at page 178, it states in the third paragraph, and whereas section 24(1) of the NPA provides that a DPP has, in respect of the area for which he or she has been appointed, the power to do various things. It just quotes the section again. If we go to page 179,
Just remember, you are trying to find a section that says Advocate Chauke acted in excess of his authority by getting involved in a KZN matter.
I'm answering the question.
Well, okay, well, show us then the passage.
I'm answering the question, Council. Sorry, Chairperson. Chairperson, at page 179, it states the issues to be determined by the inquiry are set out below. And then if we go to Roman 2, it says, insofar as it relates directly or indirectly to the conduct of Advocate Chauke and his fitness and propriety to hold office. Oh, sorry, that's not what I should be reading. Roman 2, whether in fulfilling his responsibilities as Director of Public Prosecutions, first bullet, Advocate Chauke complied with the Constitution, the National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority. Chairperson, if we also look at the bullet on page 180, the second round bullet, and this may not be the only ones. Advocate Chauke exercised his powers and performed his duties. Well, before that, Chairperson, the first bullet, Advocate Chauke duly respected court processes and proceedings before the courts as required by applicable prescripts and as a senior member of the NPA. And the bullet next one, Advocate Chauke exercised his powers and performed his duties and functions in accordance with the prosecution policy directives as determined under Section 21 of the NPA Act. Chairperson, certainly it does not specifically state, those words are not used here, that he acted outside his jurisdiction, but everything that I've read indicates that very aspect. It requires Advocate Chauke to exercise powers as a DPP within his area of jurisdiction. And all of these paragraphs that I have mentioned must be read with the conduct when Advocate Chauke exercised powers that were not granted to him by the Constitution or the NPA Act. In that, he exercised them outside of his jurisdiction.
See, Advocate Batohi, you've now summarized a new term of reference, which would have been one sentence. Why did you not include it in the draft?
Chairperson, I don't know. I can't answer that. So if it's a mistake, it doesn't mean this inquiry can't. The purpose of this inquiry is to inquire, in my humble view, into the conduct of Advocate Chauke. And certainly it cannot be if there was an oversight or if it was drafted in a way differently to what council thinks it should have been, that it should in any way constrain this inquiry.
So you see this inquiry as also fixing your mistakes and your oversight and your sloppiness in drafting.
That's your comment, and I will not respond to that.
But you are the one who said that merely because there was a mistake, merely because there was an oversight, should not constrain the inquiry. So it's completely justified for me to put it back to you that you see the role of this inquiry as fixing your mistakes, fixing your oversights, and fixing your sloppiness in drafting.
Council, you think you justified. I don't. We can agree to disagree on that.
Are you going to answer the question or not?
I disagree with that.
So you don't see this as the job of this inquiry to fix your mistakes and fix your sloppiness in drafting?
I do not see it as the job of this inquiry to fix my mistakes or my sloppiness.
Yes. Now, when you look at the draft letter from page 181.
I should add that that is your.
Pardon, Council. Council asked you a question, you answered, and he's now asking you another question, then you answers whilst he's asking you. I think it is important, Advocate Batohi, to accord one another the respect and just to observe the decorum.
I have absolute respect for Advocate Ngukai Toby, Chairperson.
Well, you can say it, but you don't show it.
I apologize, Advocate Ngukai Toby.
Look, there's no need to. Anyway, thank you for the apology. Let me not poison the water already.
It's 11:15. You may pause where the apology is 11:15. You just pause where the apology is given, and you will continue when we reconvene after the tea adjournment.
Thank you, Madam
Just
Chair.
remember the point where you stopped, and then we'll take it from there. We'll adjourn for tea
As you
until 25 to 12.
It uses no evidence.
That's correct.
Yes. That document, again, when it comes to the matter of Lieutenant General Mdluli, is limited only to the decision to withdraw the charge and to refer the matter to an inquest. It does not refer to the failure to reinstate the charge after the inquest, or the failure to reinstate the murder charge, after the judgment of Judge Murphy?
That's correct.
That document also does not mention anything wrong with Mr. Chauke's decision to instruct an appeal against the judgment of Judge Murphy in the matter of Lieutenant General Mdluli.
That is correct.
Yes. Thank you. Might we move on to the next topic? When we adjourned, there was a third issue to be dealt with, which was the question of the instruction to Advocate Hilton Epstein. Can I understand what your evidence is? Is it that you don't recall the entire interactions with Advocate Epstein or not?
The position is that I had interactions with Advocate Epstein. I remember that. I recall broadly that he had been briefed by Advocate Abrams in a number of cases, and the meetings we had dealt with the status of those matters generally.
Can you explain why you never disclosed this episode of the involvement of Mr. Epstein, despite you being completely aware of that fact?
I didn't think it was relevant at the time. But I'm here to answer questions. I'm happy to talk about it.
Yes, so it's not about having forgotten. It is about a deliberate choice that you will not disclose it because it's not relevant.
No, that's not correct. If I can please clarify that. It was not a deliberate choice. It's not like I thought about my interactions with counsel, Advocate Epstein, and decided not to put it in. That's definitely not the case at all. We were trying to put together my affidavit, and I think maybe we need to go back to the timelines under which we did this. And I think everyone is aware of that, so I won't go through it again. But I had a couple of days, amongst other things, an appearance before Parliament. I'm not making excuses. All I'm saying is that we tried to put in my affidavit aspects that we thought would assist this inquiry. And I'm not trying to withhold that. I didn't even think about Mr. Epstein at the time, but I'm happy to discuss any aspect of my meetings with him. I've got nothing to hide at all.
Now,
Madam Chair, with your permission, may I ask to interpose with respect to my learned colleague? I'm advised by the NPA team that at the time of the settling of the NDPP's affidavit, there was no instruction about the Epstein issue. And I'm asked to convey that and to put it on record.
I don't understand, Council. Are you suggesting that the issue regarding interactions between Advocate Batohi and Advocate Epstein was not brought to the evidence leading team?
No,
Or what?
was not brought to the attention of the NPA, rather the attention of Advocate Hali at the time, and the evidence leading team as well, when the affidavit of the NDPP was settled. In other words, it is a response to Advocate Ngugaitobi's issue that Advocate Batohi has not bring that to light in her affidavit, disclosed the interactions in her affidavit.
And Advocate Batohi sought to answer that question the way she did. Are you taking issues with her answer?
Not quite. I was just asked to put it on record. I'm not taking any issue with it. Her answers will remain. Those are her answers.
Shouldn't you leave this aspect for re-examination, because those are matters that you can clarify maybe in re-examination,
Yes,
not now?
I agree.
Thank you, Madam. Oh,
I
sorry.
see Advocate Halley is raising the hand. Would you please confer with him?
Is based upon questions which we have not consulted with our witnesses. I don't believe the examination of our witnesses ask them to
Madam Chair, Advocate Hali is requesting that he be given an audience on this aspect.
We will confuse this record. As you know, Senior Counsel, you will have an opportunity later when you re-examine. We cannot have